North Carolina's legal battle over absentee ballot rules has moved to the nation's highest court. And among the many groups taking interest in the case, a group called True the Vote. Joining us to discuss the case now is the attorney for True the Vote, James Bopp Jr. Thanks for taking time to chat with us.
Really great to be on with you.
So first of all, before we get into True the Vote's interest in this case, remind us what this group is and why it's interested in elections and election integrity.
Well, True the Vote was established over 10 years ago, and it's the leading group seeking to ensure the integrity of our elections. And they do so in several different ways. One is to examine voter rolls and reveal and push for the cleaning up of voter rolls, because that's a huge problem. Secondly is this year they have gotten involved in lawsuits to combat the Democrats' now multi-year, multi-million-dollar effort to first strike down all anti-fraud protections that exist within our election law system. Two, to flood the country with mail-in ballots so they can then be harvested and pulled out of mailboxes, etc. And then have as much litigation as possible. There's currently 417 cases pending in the United States, brought by almost all brought by Democrat allies, to accomplish what I'm just talking about, because they want to create mass chaos in our election system so that after the election, they can have judges and lawyers, not voters, decide who wins this election. So that is what True the Vote is helping to fight.
Now, True the Vote is not a direct party to the case Wise v. Circosta, which is one of the two cases in front of Chief Justice Roberts, but you've asked, and all parties seem to be in support of, or at least not in opposition to, you joining as an amicus or friend of the court. Tell us what piece of the argument you're putting on the table for Chief Justice Roberts and potentially the entire Supreme Court to consider.
Well, I think the Supreme Court has got to get a handle on this situation, and the sooner the better. And when you have 414 cases, I mean, some of us remember, and I was a key participant in Bush v. Gore in 2000. I mean, there was only 3 cases that was going on. One of them was my case on behalf of voters to stop the effort by the Democrats to find votes by changing the rules for how you count votes. And of course, ultimately, the Supreme Court stopped that effort. That was just one state with 3 cases. We now have 20 or 30 states with 414 cases. They are trying to flood the courts in order to overwhelm the Supreme Court so that state courts such as Pennsylvania's or North Carolina's, that is now controlled by Democrats, can decide the outcome of the election regardless of how the voters vote. So they have got to do something now to control this flood and to foil this effort that the Democrats have launched. And that is to create clear standards. I mean, one of the key issues, which is in the North Carolina case, and has been in several of the cases we've litigated, is the constitutional provision in the U.S. Constitution that provides that the time, place, and manner of elections will be, quote, prescribed by the legislature of the state. So it's not the courts. It's certainly not bureaucrats at the election board, now controlled by the Democrats in North Carolina, that can determine the rules by which elections are to be conducted. It is the legislature. It is prescribed in the U.S. Constitution for the legislature to do this. But of course, in your state, even though the legislature recently met, figured out how to adjust for COVID-19, changed a few election laws, what they didn't change is the deadline for ballots to come in. And of course, then the election board proceeded to vote, screw the legislature, heck with the U.S. Constitution, and for that matter, the North Carolina Constitution, and we're going to decide to count ballots that are received after Election Day. The Supreme Court needs to reassert the constitutional requirement that bureaucrats, that state officials, that not even state courts can change election laws on the eve of an election, and like North Carolina did. If they would do that, they would prevent the vast majority of this manipulation that is going on. We've got governors, we've got secretaries of state, we've got state election boards that look at state law and say, heck with it. We don't like this state law. It doesn't do what we think ought to be done. We're just going to change it. And of course, inevitably, these are Democrats that change it in a way that strips away all the fraud protections, creates chaos, floods the state with ballots, so that after the election, the courts and the lawyers will decide who wins, not the voters. That's the plan. They're executing that plan right now. We've got to stop it. And the Supreme Court's the only one that can do that.
In fact, in your brief, you label this a unique opportunity for the court to step in and do this. We're speaking with Jim Bopp, who is an attorney for True the Vote, a national election integrity group. Don't want to get too much into the legal weeds, but at one point here, you talk about looking at what the Constitution actually says, and you apply a couple of other tests that people who are lawyers might understand, something called Anderson, Burdick, and Purcell. How do all of these things work together in such a way that the plaintiffs in this case, Republican legislative leaders, Trump campaign, Republican National Committee, and North Carolina voters should win?
Well, the Supreme Court has handed down two lines of decisions that protect the legislative prerogative for setting election laws, for establishing election laws. One is a test for determining the constitutionality of a legislative enactment. And that test is called Anderson and Burdick. Those are the names of two cases that establish this line of cases, which are very deferential. I mean, they are premised on the idea that the Constitution gives the state legislature the authority to determine election laws. And then when somebody challenges those, it's a very deferential test that that defers in large measure, not completely, but in large measure, to the legislative determinations on things like what is necessary in order to protect the integrity of the election, what is necessary to prevent fraud, and what kind of safeguards do we need, and there's a balancing of a lot of interests. When you have safeguards, you are also making it a little more difficult to vote as well. Like if you have a signature, like somebody has to witness, your ballot, that you're going to send in.
As we do here in North Carolina.
Exactly. And or compare the signatures between the application that you filled out in order to get a ballot sent to you, and then the ballot, when it comes in, you've got to put a signature on that too. And they compare those. So while these make elections, a little more burdensome, a little more difficult, at the same time, they ensure that we don't have ballot stuffing and we don't have people stealing ballots and mailing them in. Because if you don't have to compare the signature, well, then why not just go to all your neighbors and look at their mailbox? Or if you are a U.S. postal employee whose union has endorsed Biden, why don't you just steal some ballots while you're at it? Okay, so if you don't have the signature requirement, all of that activity is encouraged. Okay, so it's a balance. So the Constitution gave that balancing job, integrity versus access, fraud versus ease of voting to the legislature, and so the court defers to that. And through this Anderson verdict test, which defers to the legislature in large measure. Now, the second way they protect the legislative choices for election law is what's called the Purcell principle. And this is a restraint that the Supreme Court has established in the Purcell case on federal courts from intervening in an election and changing the legislative rules right at the eve of an election. You know, I mean, we have we have some of these rules that they are challenging, like signatures or witnesses or whatever, have been around for decades, all right, to protect the integrity of elections. But then all of a sudden, the Democrats come in, you know, 2 months before an election, you know, as they have done dozens and dozens of times. There's more than 400 cases right now pending, trying to change these long-standing legislative rules. And of course, what does that do? It creates chaos. All of a sudden, on the eve of an election, you're changing the rules. All the poll workers have been trained, prepared, ready, you know, to conduct the election under long established rules. All of a sudden, in comes the federal court changing the rules. Well, it creates chaos. And it means that after the election, they set up what they want, their goal is to set up, which is all of these election officials struggling with these new rules and implementing these new rules. And then I flat guarantee it. Every time some poll worker pulls out the application, sees the signature, okay? Pulls out the mail-in ballot, sees the signature, and says, well, these don't match, I'm not going to count this ballot. Bam, there's going to be a federal lawsuit. You think 414 lawsuits in 20 states is a lot? Wait till after the election. They're going to sue every single ballot that is not cast, right? Because they want the judges and the lawyers to determine the outcome of the election, not the voter. And by creating this chaos, changing the rules on the eve of election, you guarantee, you know, that poll workers are going to have a difficulty in, you know, all of a sudden the rules change. Oh, I'm sorry, what are we supposed to do here? You know, and boy, they're ready there with their lawyers, watching them, ready to file lawsuits. Okay, and to do that. So that's that. So what we've told the court is, look, you've got to clarify that those two rules about deferring to the legislature on the one hand and preventing last minute changes on the other hand is to protect the legislative choice, okay? And if state bureaucrats like in North Carolina come in and change the rules on the eve of the election, they shouldn't be deferred to. They're not the legislature. You know, the court needs to come in and stop them, all right? Because the chaos is caused by the state election board by changing the rules right before the election, not by the courts that are stopping them from doing that. Now, but what you see is the North Carolina election board that's changing the rules on the eve of the election by overturning an existing state law. They're saying, oh, well, you court can't stop us from changing the rules because you're going to create chaos, okay, by changing the rules. No, they changed the rules, right? They changed the rules from the legislative enactments, and so they're the ones that need to be stopped, not the courts who are correcting them from doing this.
Right now, this emergency appeal is in the hands of Chief Justice John Roberts, who hears the emergency appeals in the Fourth Circuit, which North Carolina is in. If the Chief Justice, and presumably with consultation with his colleagues on the Supreme Court, if they decide not to act here, what problems does that create?
Well, of course, what is customary is that the circuit justice refers the matter to the entire Supreme Court. I mean, I hope he does that. I mean, this is something that now we've had several appeals, one of which I took from Montana because we had the governor changing the rules, the election laws, overturning all sorts of election laws by fiat. You know, they need to take one of these cases and clarify the rules. Uh, and the North Carolina case, I view as ideal. Uh, you know, there was a recent case out of Pennsylvania where the Pennsylvania Supreme Court changed the rules. Now, this is a court, 7-2 Democrat, you know, who you know, is reading the playbook of the Democrats, changed the rules by applying by claiming that the state constitution prevents certain of these state election laws from going into effect. And that created a complication. Okay, in other words, what role does a state Supreme Court in applying the state constitution have with respect to the U.S. Constitution's saying it's the legislature that should do this? So that created a complication. They didn't. Chief Justice Roberts joined with the three liberals and refused to intervene. But see, the North Carolina case doesn't have that. It doesn't have the state, you know, Supreme Court coming in, applying the state constitution. You know, these are just bureaucrats appointed by the Democrat governor who just a few days after the legislature says, no, we're not going to extend the deadline, says, heck with you. I'm the election board person. Okay. I'm the bureaucrat in charge of this. Legislature, forget about it. Okay. I'm in charge. I'm doing this. Well, that can't be the legislature. Some bureaucrat who's appointed by a Democrat governor is not the legislature. Surely they understand that and cannot have any legitimate role in changing what the legislature has adopted as the state law.
Well, it's obviously a very important case and will have an impact, a ripple effect on many other suits that could come along the line, especially if the Supreme Court does not decide that legislatures have this role that you've spelled out. James Bopp Jr. is an attorney who represents True the Vote, a national election integrity group that is very interested in Wise v. Circosta and Moore v. Circosta, the two North Carolina cases that are in front of Chief Justice Roberts now. Thanks so much for sharing your perspective with us.
Pleasure. Thank you.